So we have a template on motion to sign order, and this is just a small template, but this shows you can create a template for anything. And maybe there's just one thing that you think you or your staff needs a reminder of, and so you build a template, and every time you do that, you go to that template. And you can add on to the template. This only has 3 things on it, but I noticed that we were dropping the ball on one piece on motions to sign. So when is a motion to sign? When would that happen? Let's say that you've been to mediation, you have a mediated settlement agreement, now you've drafted the order, you cannot get the other side to reply. They won't reply, they won't give you changes, they won't sign it, they won't refuse to sign it, they're just not replying. Well, your client would like the case to end. So you have a right to file a motion to sign with the court and ask them to sign an order that is consistent with the mediated settlement agreement. And the law says that your client has a right to that. But when you file that motion to sign, what I was seeing we were dropping the ball on is you need to attach the mediated settlement agreement that you're referring to and your proposed order so the court can see that it matches. And then the other side, let's say they then wake up because you've now filed a motion and set it for hearing, they could do the same thing. But you both need to see what the other one is asking the court to sign. So you don't just file a motion that says please sign an order. You need to attach what you're asking them to sign. You need to say in your motion that it is consistent with the mediated settlement agreement, and it needs to be. So you don't just get to throw extra stuff in there. You really have to narrow it to exactly what the mediated settlement agreement says. Sometimes we will throw not extra stuff like we're trying to be tricky, but mediated settlement agreements are brief, and sometimes we'll have extra language that we view kind of as a proposal to the other side. Well, if they're not responding, that has to come out. So you're really down to exactly what the MSA said and nothing else on your order, on your motion to sign. Now, if that does get their attention, their reply, you can negotiate back in that broader language that maybe you don't even think they would object to if you could get their attention. But this is a good way to end the case if you can't get it quite to end. And we have simple things in the template like set it for hearing. I have check with the opposing counsel's calendar. I don't like it when we don't check with their calendar. At least if they won't reply, which maybe that's the problem, they won't reply to that either, at least look at their vacation letter, because otherwise you're going to end up having to reset the hearing because they're going to come back and say, well, that date wasn't good for me and you didn't even check. So it's better to just have the practice of checking with their calendar, or at least look at their vacation letter. And that is our motion to sign order template.